Okay, let's get started. Today is lesson 8 of Colorado Contracts and Regulations. My name's Jim McCloskey. And let's go to page 17-1. 17-1. And what we're going to be doing is looking at contracts. There's more questions on contracts on the state exam than any other subject. If you blow the state exam, you blow it because of contracts. And we have a ton of contract questions for you before you take that state exam. No excuse for you to ever flunk that state exam because of contract questions. Now, I like these couple paragraphs starting on chapter 17 up on top there. Together with the laws of agency and brokerage relationships, an understanding of contract law is essential for real estate practitioners. A licensee constantly reviews contracts for purchases, lease agreements, and mortgages. In Colorado, real estate licensees are allowed to fill in blanks in standard contract forms. The competency and professionalism of the real estate licensee are always at stake when contracts are being written or explained. Of all legal instruments, contracts are among the most important to our society and economic system. The stability and security of our business world are dependent upon the law of contracts. It ensures that the parties perform their agreement by requiring that they either perform or pay for all loss or damage caused by non-performance. Furthermore, the specialized branches of business law, such as the sale of goods and services, negotiable instruments, partnerships, and corporations, are all founded upon the law of contracts. I like this definition, one of the best I've heard, condensed like this in 2 lines. A contract may be defined as an agreement between 2 or more competent persons, having for its purpose a legal object wherein the parties agree to act in a certain manner. Very nice, very well explained. And they're essential elements of a contract. We have mutual assent. What are you going to write on the side there or above it? What is the same thing as mutual assent? Mutual consent, meeting of the minds, mutuality. Write that around there somewhere. Mutual assent, mutual consent, meeting of the minds, mutuality. Mutual assent, mutual consent, meeting of the minds, mutuality. And what's that mean? It means we're all acting in good faith. Nobody's playing games. Our goal is to get to that closing table. Now, what are the main parts of a contract? Virtually any contract, but especially a real estate contract. You have A, right below there, an offer, and look at the bottom of page 17-2, at the bottom, B, acceptance. Offer and acceptance. You have offer and acceptance. Those are the 2 main issues when it comes to transferring contracts. You have offer and acceptance. When does that happen? When do we have offer and acceptance in a closing? At the closing table, during the closing. Remember, the buyer walks out of that closing room owning that property. He owns it as soon as he reaches out and grabs that deed. He owns that property. I thought that happened when they recorded the deed. Well, why record a deed then? Constructive notice, that no one on the planet can say that they don't know I own this property. Constructive notice. And there's 2 ways to give constructive notice. I can either have it recorded or take possession of the property. Those are the 2 ways I can give constructive notice of my ownership interest. Okay, look on page 17-3. Kind of right in the middle of the page, about the 3rd paragraph down, where it says fraud and misrepresentation. Fraud and misrepresentation are self-explanatory and, when present, permit the innocent party to cancel the contract and, in appropriate cases, to recover damages suffered. Undue influence consists of the abuse of the control or influence that one person has over another because of their relationship. Duress consists of compelling a person through fear to do or to agree to do an act. Statute of frauds. You're going to hear this many more times. This isn't fraud. This is the statute of frauds. To prevent fraud through perjury, the law requires that the parties' agreement evidencing their mutual assent be in writing in certain cases. As to real estate in Colorado, the statute provides that every contract for the leasing for a period for a longer period than 1 year, or for the sale of any lands or any interest in land is void. Void unless the contract or some note or memorandum thereof expressing the consideration is in writing and described by the parties by whom the lease or sale is to be made. So the statute of frauds says that all contracts for real property must be in writing or they're void through the statute of frauds. The exception are leases for less than a year. Where would we have leases for less than a year? Remember the different types of leases?
At will?
In a state at will. Where I have my buddy Joe stand in there, down there, because his wife kicked him out or something. I'm probably not going to have a signed lease with Joe. And I don't need one. Hopefully it won't be for a year. You know, it's not going to be for over a year, so I can have a verbal agreement with him. But this statute of frauds is very succinct. It was for over a year or more. You have to have a written contract for any lease. For any sale of real property, you have to have written agreements. Verbal agreements don't work. I had a buddy of mine call, this a few years back. I hate to even tell this story. But anyway, he called me, he said, I'm going through a tough time. Can I just sack out at the office for a couple nights? I said, yeah, come on. So he did. He stayed for 10 months. I could not get rid of the guy. And he'd been my friend for several years. I did not know this. But what he is, he's a closet alcoholic. He drinks those Bud Lights. So he'd sip on them 24/7, just keep an even high, I guess is what he does. And anyway, I mean, it was really bad. It got to the point where I'd take a break and he'd come in and start teaching. I mean, really weird stuff going on. So finally, how much notice do you have to give for a state of will?
3 days.
3 days. So I gave him a 3-day notice of eviction. 3 days went by, he completely ignored me. And I wasn't going to go get the sheriff to have me evicted. And so a couple days later he left, and while he was gone I changed the locks and got rid of him. But again, it's an awkward situation. You always want to have a written contract whenever possible.
Is he still your buddy?
No.
You locked him out?
Yeah. Anyway. Let's go to page 17.4, the parole evidence rule. The parole evidence rule. Remember, we just talked about that 15 minutes ago on the contract. Parole means word or speech. Word or speech or verbal. Parole evidence rule. If we had any verbal agreements that they didn't make it to this contract, they never existed to begin with. Parole evidence rule. Consideration. We've talked about this many times. Consideration is something of value for something of value. I'll give you $400,000, you'll give me your house. Consideration. Consideration. So again, something of value for something of value. Second paragraph there on number 2. Where it says consideration may be defined as a promise or an act of legal value bargained for and received in return for a promise. Promise for a promise. Look on top page 17.5 and look at competent parties. Let's read this. All parties are presumed to have the legal capacity to enter into contracts, but certain persons, for reasons of public policy or some disability, do not have full contractual capacity. Among these are minors, mental defectives, and intoxicated persons. In Colorado, a minor is an individual under 18 years of age. Minors have the right to cancel or disaffirm their contract with no liability other than the return of any proceeds they received under such contract. Minors are given this right to protect them against their lack of experience, judgment, and ability. The burden is upon adults to ascertain that the person they deal with is of legal age. After reaching legal age, minors may ratify or approve previous contracts with which will then be binding upon them. If you sell your car to a 16-year-old, they can drive it for a year and come back and get all their money if they wanted to. You'd never have a contract with someone under 18 years of age unless they've been emancipated. Emancipated. And there's 3 ways you can be emancipated. You can get married, join the service, get married, or your folks can have you emancipated. I raised 4 girls, 4 daughters, and every one of them, when they turned about 14, we were really tempted. Really tempted. I know our youngest one, she went into her room one time, was mad at us. And she came out, she dyed her hair just terrible purple. Some of you millennials would love it. You really, anyway. But she came out and we said, great. You want to wear that on public? Go for it. She started crying. She went into her room and shaved her head. Teach us a lesson. Isn't that something? Anyway. I earned these gray hairs, I'll tell you. Anyway. Then they turn 21, their brain clicks back on again. It's amazing. Amazing. And then the next paragraph here. Insane persons are given the same protection as that given to minors, except that the contracts of a person judicially, through the courts, declared insane could never have had effect in the first place. You're criminally insane would be a good example of that. You can't enter into contracts. Now, let's go over this. Let's write these down. There are 4 ways a contract may be void. And they are, some of you have heard this ad nauseum. I don't care. You need to know this for real life too. 4 ways it may be void. Illegal purpose. Illegal purpose. Insane by a court. Insane by a court, like legally insane. Signing the contract before the lead-based paint disclosure will void that contract. You have to get that lead-based paint disclosure signed by who? Buyer and seller and the brokers. The brokers have to sign that lead-based paint too. And what's the 4th one?
Statute of frauds.
Statute of frauds, a verbal contract through the statute of frauds. One more time. One more time. Illegal purpose. Verbal statute, a contract through the statute of frauds. Insane by a court. And illegal purpose. The 4 ways a contract may be void. Now there's 4 ways a contract may be voidable, where the injured party can cancel it without penalty. Voidable. Pardon me? Yes. Illegal purpose. Insane by a court. A verbal contract through the statute of frauds. What'd I miss? What's that? I still didn't hear you.
Lead-based paint.
Lead-based paint. Signing the contract before the lead-based paint. Yeah, those are the way it can be. Void. Now voidable. Voidable. Like someone under 18, they can, it's up to them whether they want to void it or not. You sold them a car when they were 16, they can bring it back to you a year later and get all their money back if they wanted to. It's voidable by them.
Now, what happens if they turn 18? Are they still eligible to bring it back?
No, then all of a sudden, they can either keep that car or not, but now, if they use it and they possess it, in court, it'll stand up that they do own that car. Yeah, but while they're underage, poor little babies, they didn't know that they couldn't do that, you know. And so voidable would be what? Number one for voidable would be insane by a doctor. Remember, by court, it's void. By a doctor, it's voidable. What else? Help me out.
Duress.
Duress. Someone forces you to sign a contract. Duress.
Can you spell it?
D-U-R-E-S-S. Could be 2 R's in it. Duress. Again, someone forces you to do a contract. Another one would be fraud. You think fraud would make it void, and no, it's voidable by the injured party. So fraud is voidable. Fraud is voidable. So we have again, insane by a doctor, duress, forced to sign something, fraud, and what else?
Underage.
Underage, we just talked about that. Underage, under 18. Voidable and void, two completely different things, guys.
So void is for the seller, voidable is for the buyer?
No, voidable is, who's ever entering into the contract, it's either void or voidable by that person who's entering into the contract. Okay?
So, just so I understand this clearly, so a contract is not legal, it's void if these items, or if these ones, but if the person is claimed insane by a doctor, do they have to have someone come forward and say, this contract is void because this person, like, if they don't do that, if they don't void the contract themselves, does that mean it's not?
No,
Voidable?
again, it's voidable.
Right.
If the doctor declares you as incapable of being insane or whatever.
Right, so what I'm trying to ask, and I'm not asking it right, is like, so a minor, if I buy a car from you and I'm a minor, and I don't come forward and say, hey, I want my money back, this contract's not valid because I'm a minor, does that mean the contract is valid because I haven't made it voidable? You know what I mean?
No. You are the one who was underage.
Right,
And you want to cancel that contract the next day, whenever, you can cancel it anytime you want to,
okay.
till you turn 18. We'll talk about that here in just a little bit, like it says right in here.
Voidable will just stand up in court. It's basically void, there's no way of standing up in
No,
court.
it's not going to stand up in court at all.
Stands up.
So, and, you talk about fraud being voidable, you think that'd be void. No, it's still voidable. But again, it's so hard to prove fraud. You almost have to read somebody's mind, unless they're stupid enough to put it in writing, which a lot of people are, so. And then the next paragraph says, insane persons are given the same protection as that given to minors, except that the contracts of a person judicially, through the courts, declared insane could never have had effect in the first place. And then the contract we talked about the contract of an intoxicated person is usually binding, except where that person is so intoxicated as to be incapable of understanding the nature of the transaction. In that case, the intoxicated person may cancel or ratify the contract. Who makes that decision? Isn't that something? So you go to a closing and somebody shows up at the closing just totally drunk. This only happened one time to me. It was an early closing. It was like 8:30 in the morning. And this guy showed up just totally sloshed. And what happened is that they all said, well, we'll close tomorrow. But what happened, the closing lady had enough, she had enough on her plate. Tomorrow wouldn't go to work. So she reset that closing for 4:30 that afternoon. And by then, I was totally sober. Anyway. So who makes that decision? That's kind of a tough one. Like, what he says it after the fact. Here's my empty bottle of Jim Beam. I drank this whole thing before the closing and nobody said a word. How about legal purpose? To be valid and enforceable, a contract must have a legal object for its purpose. The object cannot be to violate a valid statute. An agreement to commit a crime, a tort. Let's talk about a tort. A tort is a private wrong, a private wrong. You're not going to go to jail for committing a tort. It's a private wrong. One of the words that describes that is tortious malfeasance. You'll hear that called. You were guilty of tortious malfeasance. It wasn't a felony, but it's something that they could have pay restitution for, or something like that. Or something contrary to public welfare is illegal. For example, an agreement to defraud someone, slander a person, or operate an unauthorized gambling operation is illegal. Dual contracting to induce a lender to make a loan on real estate without knowing the true terms of sale, such as the actual amount of down payment, is a criminal offense under this statute. So again, I have a legal contract and a phony contract. I use the phony contract to get the loan. And matters to be considered in real estate contracts. This is interesting here too. The buy-sell contract is the most important document in a real estate transaction. This contract determines the kind of title to be conveyed, the type of deed, liens and circumstances that the land will be sold subject to, and the manner of payment of the purchase price. Numerous controversies involving real estate licensees arise out of contracts for the sale of property. Although dishonesty or wrongdoing on the part of the licensee is rare, disputes often stem from the licensee's lack of thoroughness or knowledge. Real estate brokers must continually strive to increase their own proficiency and that of their employed licensees in writing good contracts. Boy, this is really well written, this whole thing right here. It is an art to write a sound, workable contract that includes all important matters and is still reasonably clear and understandable. Although Colorado licensees are fortunate in having commission-approved contract forms available, they must nevertheless pay close attention to completing these forms in a competent manner. The following are the main items to be considered in drawing up real estate contracts. This list is not intended to be exhaustive. Seldom are two real estate contracts or transactions alike. Only through careful study, experience, and guidance will the real estate licensee learn to recognize the essential items to be included in a given transaction. And the perfect contract has never been written. It never will, because it could always be improved. But you want something that's understandable and easily explained to everybody there. You see some of these attorneys with these long paragraphs with no periods or commas in them. I don't know if they're just trying to show off or not, but I think that's the most unimpressive thing I could ever see in any type of documentary at all. Any type of narrative is a stupid 10, 12, 20, 30 line paragraph. I mean, that's just careless. Or intentional. Very tough to understand. So what are the parts of a contract? They're the same things as parts of a deed of trust, parts of a lease, with very few exceptions. If you know one of these lists, you pretty much know them all. The names and signatures of the parties, the sales price and payment provisions, C, the description of the property, and types of deeds. How many types of deeds are there? 4. Good. The condition of the title. Is it marketable or merchantable? Default provisions. What are our 2 default provisions in Colorado? We just talked about them.
General warranty deed.
No, those are deeds. What are default? If we default on a contract, what are the 2 remedies or penalties?
Liquidated damages?
One is liquidated damages, which means what?
You keep the deposit.
Only the earnest money's at stake.
I lose my deposit,
Right.
right? I lose my deposit, liquidated damages, and the other one is,
Where they force you to either buy the property.
exactly, what's that called?
Performance.
What kind of performance? There we go, between all of it, you got it. You all got it. So specific performance and liquidated damages are the two remedies for default in Colorado. Contingency provisions, see all those contingencies, every one of those lines in that contract is a contingency, and we don't have a contract till all of those dates have been satisfied. Guys, okay?
Performance.
Well, specific performance and liquidated damages are two remedies for default. When you see the word remedy, it means the same thing as a penalty. And possession. If the time of closing the transaction is different from the time that possession of the premises is to be given to the buyer, the date and time of possession should be stated. And apportionment or adjustments, and those are prorations. Those of you who are going to start closings next week, you guys will know prorations real well by the time you're through. Who plans on taking closings a second time? All right.
I took in the videos, but I'm really looking forward to it.
Oh,
in
okay,
person.
good. And see, a lot of people think that of all the classes I should be taking again, it's closings. Then after about 2 hours of the first day, they're going, I know this stuff. I just have to study it. And again, but it's difficult. It's different than anything you've ever had before. But anyway, you're going to have them on the state exam, so you got to know them. Risk of loss. If the property is damaged or destroyed by fire, flood, or storm after the contract is signed but before the deed is delivered, who suffers the loss, the seller or the buyer? The answer is not as simple as it seems. In most jurisdictions, when a binding real estate contract exists and where either party may enforce specific performance, the loss falls on the buyer, who is considered the owner of the property. The buyer holds what is known as equitable title, even though legal title has not yet passed. At time of contract in Colorado, we then have, again, not legal title, but equitable title. At time of contract, and we keep our equitable title all the way up until we close, then we still retain our equitable title, but we now have legal title because that's when we get our deed. And the buyer can legally force the seller to convey the legal title. Also, the seller can force the buyer to accept the legal title and perform their part. This right is called specific performance. The parties lose this right only if they waive it in the contract. And some courts interpret equitable title theory as unjustly putting the burden of loss on the buyer. Being not in possession, the buyer is unable to protect his or her interest. And then my least favorite word, however, cancels all that out. However, the majority of courts seem to hold that the loss falls on the buyer, unless the contract provides otherwise. To avoid potential misunderstandings or controversies, it is important to clearly spell out risk in the contract. It is not unusual for the contract of sale to provide that the risk of loss remains with the seller. And of course, that's what we do in Colorado. The risk falls to the seller, not to the buyer. But in some states, the buyer is liable. Is that backwards or what? Just really strange laws. And those are laws that the voters voted in. That would be something they voted in. You hear about all these crazy laws around the nation that are voted in by people. In 2012 in California, they voted in this tax that made it retroactive back to 2007. Who votes for a retroactive tax? I mean, that is just ridiculously stupid. Anyway, and I can talk about some other ones too, but my blood pressure goes up too badly, so. Anyway, vote intelligently or don't vote. And most people in these liberal states back east, a lot of them, not pointing the finger at anybody, you vote in these ridiculous liberal laws that you can't stand to live in that state anymore, so you come out here and vote them in out here. We used to be a very conservative state at one time, and we're going the other direction, which is just really sad to see. Anyway, that's my opinion. Let's keep going. Page 17.9, fourth paragraph. Earnest money deposits are another critical element of any contract. Earnest money should be adequate to demonstrate the buyer's serious intent to purchase, and in the event of the buyer's default, to compensate the seller for the act of taking the property off the market during the period prior to closing. Earnest money should apply only to partial payment of the purchase price. The form of earnest money, check or promissory note, must be specified in the contract. We're going to be going over settlement statements next week. All that information, that settlement statement, comes from the contract. From the contract. So put that in parentheses or something. Again, must be specified in the contract. If it is a note, it must have a definite due date. The Commission strongly recommends that notes not be taken with due dates of at closing. Talked about that earlier. Such notes creates confusion as to the seller's forfeiture rights if closing does not occur and the buyer is in default. And these are some of the contingencies you're going to have on the contract. We're not going to spend a lot of time on these because we kind of buried them. We went over the contract. But again, number 10, loan contingencies. Assumptions, if there's going to be an assumption of the property, the buyer's creditworthiness. Top of page 1711, balloon payments. We really don't have balloon payments anymore. We have what's called calls. A 3-year call, 5-year call, 7-year call. Those are for adjustable mortgages. Then surveys. Dual contracting and loan fraud, where again we have a legitimate contract and a phony contract. And we use the phony contract to make a deal happen. Installment contracts. After that installment contract, what are some of the names for installment contracts? We've talked about this several times. I'll help you out. Installment contracts, land contracts. They're not just for land, that's just what they're called. Installment land contracts, land contracts. Owner will carry, contract for deed. Write all those down there after installment contracts. On page 1711, second paragraph from the bottom where it says installment contracts. Right after installment contracts, put down land contracts. Owner will carry, contracts for deed are all the same thing. Installment contracts, land contracts, installment land contracts also. Owner will carry, contract for deed. All of those are the same thing. One more time.
Yeah.
Installment contract, installment land contract, land contract. Owner will carry, contract for deed. Owner will carry, contract for deed. And you don't get your deed until you pay it off. That's why it's a contract to get your deed later. It's kind of like buying a car. You don't get your title till it's paid off. Same with an installment land contract. Owner will carry. You don't get your deed till you pay it off. So during the entire time that you have the loan, you have equitable title because you haven't received your deed yet. You don't have legal title till after you pay it off and the seller gives you your deed. Very bottom of the page, let's read about these installment contracts, last paragraph. There is significant potential for harm to the seller, buyer, or assignee if the installment land contract is not properly drafted. Real estate brokers are prohibited from drafting a contract document that will reflect the terms of such a transaction as it would exceed their level of competency and is a matter requiring the expertise and advice of an attorney. Additionally, such behavior may be construed as the unauthorized practice of law by the real estate broker and subject to civil penalties. The contracts for these transactions should not be prepared by a real estate broker. Rather, the document should be drafted by a licensed Colorado attorney at law, engaged for each particular transaction. It doesn't say we have to use an attorney for these, but we should. So again, keep that in mind. You're going to see other questions about it. Well, this is a good one. It's page 1715. This was on the state exam the other day. First time I've seen this question. A modular home is, and just write down this question, guys. A modular home is a manufactured home. A modular is a mobile home. A modular is a prefab home. Prefab, F-A-B, prefabricated. A modular home is a stick-built home. Again, what a modular is, it's a manufactured home, a mobile home, a prefab home, or a stick-built home. Stick-built home. The answer is prefab home. It's a prefab home. They're financed just like any other home is.
You saw that question on the test?
That was on the test. Yeah, I've never seen that question before, so brand new one. Okay. Let's go over to page 18.2. Very good chapter right there, that chapter 17. Trust deeds and liens, chapter 18. Now you guys are about to become foreclosure experts. Let's look at page 18.2 and look at about that third paragraph there. It says foreclosure through public sale gave rise to a new concept of the mortgage, not as a conveyance of the land, but only as a lien upon the property. Thus, the lien would be enforced through a public sale rather than giving the lender title to the property. If the land sold for more than the debt, the mortgagee would be paid in full and the balance would be awarded to the borrower. Big star by that, and let's talk about it. You try to sell this house for $200,000, it sells for $220,000. Who gets the $20,000 extra? The mortgage or the borrower does. A lender can never make a profit on a foreclosure sale. They can never make a profit on a foreclosure sale. Now, after they get on title with that property, then it's a totally different thing. They can make all the profit they want to on the resale of it. But at the actual foreclosure sale, they cannot make a profit on it. And if it logically followed that the property sold for less than the debt, then any other asset of the mortgage or would be available to the mortgagee through a deficiency judgment, and by virtue of the borrower having signed a note or bond that was secured by the mortgage. Now, under modern mortgage law in the United States, there are three theories as to the nature of mortgages. We have lien theory, title theory, and intermediate theory. Scratch out intermediate theory. You're never going to deal with intermediate theory. It's very, very rare, and Colorado is not an intermediate theory state. Now, there are many states that are title theory states, and that's where the lender actually goes on title with you. That's why they're called title theory states. The lender actually goes on title with you. You do not get equitable title until you close on the property. You do not get your deed until you totally pay it off. That's how a title theory works. That's how a title theory works. So you give up your property as security for the debt, but you retain possession. In a title theory state in particular, the lenders write on title with you. So you actually gave up title to your property, but you retain possession of the property. That's known as hypothecation. Hypothecation. And yes, you will see one question on the state exam about hypothecation. And that's where you give up your property as security for the debt, but you retain possession. Hypothecation. That can be in reference to a lien theory state or a title theory state. Remember that for the state exam, one lousy question, and you'll never see that word again the rest of your life. But remember it for the state exam. Hypothecation. It kind of jumps out at you. I think you'll remember it.
Can you repeat?
You give up your property as security for the debt, but you retain possession. But you retain possession. Let's go to page 18.3. Well, let's talk about lien theory state. That's what Colorado is. Remember, we talked about that. At time of contract, we get equitable title. At time of contract, we get equitable title. And then when we close on the property, we retain our equitable title, a monetary title, plus we now have legal title also, because that's when we get our deed. Everybody see that money trail? Okay. Now, Colorado is a common law state. Common law state. Which means that in Colorado, to foreclose on a property, it takes about 2 years and about $10,000 worth of attorney's fees. That's why we have a deed of trust in Colorado. There's 3 legs to a trust: trustor, trustee, beneficiary. In our state, we have our trustor, the borrower, who sets up the trust. We have our lender, the beneficiary, and every county in Colorado has a public trustee. They're appointed by the governor in every county except Denver, where they're elected. So those are the 3 legs of our deed of trust: trustor, trustee, beneficiary. Borrower, lender, public trustee. Now within this deed of trust, let's talk about this. We walk into a closing. What's one of the first things we sign as a borrower? One of the first things we sign is the promissory note, or promise to pay, right? Then the next thing we sign is a deed of trust from the lender. That's our security for the debt. In most states they're called mortgages. In Colorado we're a deed of trust state. And so what happens is that in a deed of trust state, the lender does not hold on to the deed of trust. He gives it to the public trustee. And within that deed of trust is what's called a power of sale clause. Write that down somewhere. Power of sale clause. It gives that public trustee the power to start an immediate public auction on that property, which is what a foreclosure is. This clause is only contained in the deed of trust, and it's only effective if the lender gives that deed of trust to the public trustee. If he holds it himself, the lender, or he gives it to a title company to hold, 2 years and $10,000. So everybody who knows how it works uses the deed of trust. Before lenders were licensed in 2008, it was estimated that 42% of all loans were done by lenders from other states. You lose your license in Georgia or Florida, no big deal, we'll just go do loans in Colorado. They don't have any licensing. And like I say, Colorado is one of the few states that are a deed of trust state. We're not a mortgage state. And what happened is a lot of these lenders gave these buyers out here mortgages, which means they can't foreclose on this property. It'd take 2 years and $10,000 for them to do it, and they're not going to do that. There are hundreds of people still, maybe thousands in Colorado, who have a free home and they don't even know it. They could quit making their payments, and there's no way they're going to get foreclosed on, because they have a mortgage instead of a deed of trust. Yeah?
The power of sale clause gives the public trustee permission to start what?
An immediate public auction. Everybody got that? This power of sale clause allows only the public trustee to start an immediate public auction. You know, he asked the question, about 10 of you are right. Ask questions, guys. They're waiting for you to ask that question. Thank you very much. Very good question. Again, it gives them the power to start an immediate public auction of that property, which is what a foreclosure is. But only if it's held by that public trustee. Like I say, before 2008, who knows how many people out there have a free home and don't know what I'm sure there's still a bunch of them out there. You get behind on your payments, what does that trigger? It triggers an acceleration clause. The lender's going to accelerate the loan and call it due. You get behind in your payments, that creates an acceleration clause. You get behind on your payments, that triggers an acceleration clause. The lender's going to accelerate the loan and call it due. The way they will do that is they will call up the public trustee and say, start a foreclosure action against this property. Start a foreclosure action against this property. And the public trustee will then issue a notice of election and demand. Let's read about it. Second paragraph on page 18.3. Under the old and new laws, we're going to talk about the new and old laws here in just a minute. The foreclosure process is essentially commenced by the filing of a notice of election and demand with the public trustee. The public trustee then has 10 working days in which to record the notice of election and demand at the clerk and recorder's office. So you get behind in your payments, that triggers an acceleration clause. The lender's going to accelerate the loan and call it due by calling up the public trustee and, what the heck happened? What in the heck is that? What do you think? Let me see if I can get it this way. Won't pull up. Okay, now it will. See, I don't need you guys. I'm there, man.
Good job.
I'm helpless up here, guys. You guys all know that anyway. So anyway, and so again, so we're at the way it used to work, the way foreclosures used to work, and this ended January 1st, 2008. 2008 was a huge year for this nation, for this world, and especially for lending in Colorado. The way it used to be, we have two types of property, still is this way. We have agricultural, write these down, oops. Wood is not there, hold on. There. There we go. Well, I'm just getting so good, I'm telling you. Agricultural. Agricultural properties and non-agricultural. They're not single-family home and ranch. They're agricultural and non-agricultural. And the way it used to work before 2008 is once the lender issued the notice of election and demand, then that people had 10 days. It's still that way. They have 10 days to get caught up. And if they don't get caught up, they start a foreclosure action. And what happened, whether it was agricultural or non-agricultural, you had 45 days to get caught up before the property is sold at foreclosure. Once the property is sold at foreclosure, you still had an additional, if it was non-agricultural, 75 days. It was agricultural, 6 months to redeem your property. But there was a catch. The catch was, on this side, 45 days, all you had to do was get caught up, pay some late fees, and you were cool. But then, once it's sold at foreclosure, then you had 6 months if it was agricultural, 75 days if it was non-agricultural, 75 days if it was non-agricultural, and you had to pay everything off. Well, if you can't redeem here, we just got to get caught up, how the heck are you going to redeem here? That's why there were so many foreclosures. Before 2008, well, before that, before 2013, there were 600 foreclosures a week in Colorado. And so they changed everything. They changed everything in 2008. And what they did is this. Still agricultural and non-agricultural, but what they did is they said, we're just going to have one period to redo your properties, to redeem your properties. And this is how they did it. For an agricultural property, remember they notice an election demand, 10 days go by, and they start a foreclosure action within 215 to 230 days for an agricultural property. Within that time, they will sell that property, and you're out of it. You have no redemption period after that. The period before the sale is called your equitable period of redemption. Remember that, write that down. The period of time before the sale is your equitable period of redemption. The amount of time after the sale is called your statutory period of redemption. Equitable period before the sale, statutory period after the sale. Equitable period before the sale, statutory period after the sale. For non-agricultural, it was 110 to 125 days. So it's essentially the same number of days. The same number of days. Yeah.
Can you repeat that? The equitable period of redemption is before the sale?
Is the period of time before the sale. Statutory period is the period after the sale. Well, in this case, we have no statutory, do we? It's sold, see, on the 222nd day, whatever. This is sold on the 117th day, whatever. And when that day happens, there's no more redemption. You have to get out. You can't redeem that property anymore. But all you have to do is pay some late fees, get caught up, and you're fine. So we made it a lot harder to get foreclosed on after 2008. It cut down on foreclosures quite a bit in Colorado when they did this. So the main things about this that you need to know, here's some terms: agricultural property, non-agricultural property, equitable period of redemption, statutory period of redemption, common law state, public trustee. Every foreclosure in Colorado, a deed of trust foreclosure, is a trustee's foreclosure. A trustee's foreclosure. In virtually every other state, it's a sheriff's foreclosure. If you have a mortgage, it's a sheriff's foreclosure. In Colorado, it's a trustee's foreclosure. Hitting you with a lot of stuff here, guys. But again, you'll be experts in this. Yeah, Brian?
So you get your own payments, it triggers the acceleration clause, and then the public trustee will start the foreclosure, get that notice of.
They will
election and
notice of election and demand. Don't forget that.
demand. And the definition of agricultural property again?
Of equitable period of redemption, that's the period before the sale.
Non-agricultural property,
The what now?
non-agricultural property.
Well, it's either agricultural or non-agricultural, okay? Now, okay, let's talk about this. We'll skip around just a little bit, because that's a very good question. So let's talk about this. Let's go to page 18.5. Keep your fingers on that previous page. Bottom of page 18.5. How about Highlands Ranch? Everything in Douglas County is zoned agricultural. And Highlands Ranch is hardly agricultural property, right? So how is it foreclosed on? It's zoned agricultural. Let's read it down here, bottom of the page, 18.5. Look at the definitions down there. 1 and 1.5, look at that 1. As used in this article, unless context otherwise requires, agricultural property means property, none of which on the date of recording of the deed of trust or other lien, or at the time of the recording of the notice of election demand, or, here's a new term, lis pendens. That means lien pending. Write that down. There's a lien pending. In every other state, whenever a lender's about to foreclose on a property, they will file a lis pendens, letting people know that there's this action that's going to be happening. Lenders don't do that in Colorado because only the court can file a lis pendens in Colorado. Okay, that's a lis pendens. Let's keep going.
Jim,
Yeah,
I had a question, I'm sorry. You said back to what we were talking about, there were 4: equitable period of redemption, statutory period, common laws, Colorado's a common law state.
yeah,
And there was one more,
Public trustee.
public trustee,
public trustee.
yeah. And so again, recording notice or its lis pendens is if it's platted as a subdivision, then it's not agricultural. If it's located within an incorporated town, city or county, or valued and assessed as other than agricultural property. And of course, Highlands Ranch is assessed as other than agricultural property. So it's foreclosed as non-agricultural, even though it's zoned agricultural. Many counties, many counties in Colorado, there's 64 counties in Colorado, and virtually all of them have this issue, where there are areas in there where, again, they're zoned agricultural, but they're foreclosed as if they were non-agricultural. Look at the very bottom of page 18.3. What I just told you. Here we go. Highlight it. Last 2 lines. Under the new foreclosure law, if the property is non-agricultural, the public trustee must set up the foreclosure sale in the 110 to 125 day window after the recording of the notice of election and demand. If the property is agricultural, the foreclosure sale must be set up in the 215 to 230 day window after the recording of the notice of election and demand. Think you're going to see a question or 2 on the state exam about that? Better believe it. Plus, you got to know this for your people, guys. How many people know this? Nobody knows this. Some of them know the old ways, but they don't know these new ones. Let's keep going. 215 to 230-day window after recording of the notice of election and demand. Under the new law, the borrower still has until noon the day before the foreclosure sale to cure monetary defaults. Under the new law, junior lien holders still have redemption rights. However, because there is no owner's redemption period, junior lien holders must now file their application within 8 days. What the heck is that all about? So let's break this down. There's this property. The problem with foreclosures, guys, well, now they do have equity in them. But 5-6 years ago, I look at 600 properties that were going through foreclosure, and I did this a couple of times. There might be literally 3 homes out of 600 that had any equity at all. All the rest were upside down. The way you sold a home 5-6 years ago in Colorado was a short sale or a foreclosure. What's a short sale? That's where you owe $200,000 and the lender agrees you can sell it for only $150 because that's what it's worth now. A lot of those going on. And so anyway, so this 215 to 230 day window on how it works. We're looking at this house. It's worth $220,000. Okay? And it's worth, let's say that let's say that there's only $140,000 owed on it. They're only foreclosing on $140,000. And you're so happy. You're gonna go down there and knock them dead. Knock them dead. So you go walking in that foreclosure room, and you're sitting there ready to take some bids, and you take a bid, and you are generous. You offer the whole $140,000 that they're asking, and you get that property for about 10 minutes. Because what happens is the junior lien holders then kick in. There's another $20,000 lien, second mortgage, and this guy will knock you right out. Now he's sitting in the catbird seat. They have 8 days to redeem. There's a $10,000 lien. They have 5 days to redeem after this. This gets complicated. So who should you be talking to if you want to make a bid on this property? You want to be talking to this lender down here. You walk in there and say, so, you have this $10,000 third lien on this property. Do you intend to redeem your position next Thursday? And they're going to go, it's going to take me $160,000 to do that. I don't have $160,000. Say, well, I'll tell you what I'll do. I'll give you $10,000 right now for your position. Now, I'm in the catbird seat. But you know what's usually going to happen here when I say that? He's going to say, that's wonderful, but you're the fifth person I've talked to today. You know, I mean, other people have talked to this guy. They know how to play the game. So what does it mean in Colorado? Whoever comes in last wins. The one who has the lowest priority of repayment is the one who gets the property. And again, there might be a 4th, 5th, 6th, 7th, or 8th lien. All of those have 5 additional days to redeem the property. So that's how you play that game. You've got to know what you're doing. Walking in there and doing this 140, you're going to get that back in about 2 hours worth of interest, whatever that is. That's all you're going to get. You don't know how to play the game if you do that. You've got to understand how to play the game, and the way to do it is find out who are the junior lien holders and go talk to them to make a foreclosure happen. So let's read this up here. Second paragraph anyway, page 18.2, toward the top there. 18.2. No. Wait a minute. No, wrong one. 18.4, where we were. Second paragraph. Under the new law, junior lien holders still have redemption rights. However, because there is no owner redemption period, junior lien holders must now file their notices of intent to redeem within 8 business day window after the foreclosure sale, the one who's in second position. The junior lien holders still have similar sequential redemption rights, the details of which are beyond the scope of this article. It's 5 days. What's so difficult? Who's ever in second position has 8 days. Everybody underneath them has 5 days each to redeem their position. So that's how we work our foreclosures now. Let's run through this, guys. We're running through these foreclosures. So what is the redemption period for a non-agricultural property? Don't read it. 215 to 230. What's 110? For non-agricultural, right? 110 to 125. Everybody cool? And what is the period of redemption after the sale? Statutory. We don't have that in Colorado now. We do for tax sales, but not for deeded trust sales. Not for, again, trustee sales. We get a confirmation deed on a deed of trust foreclosure, a trustee's foreclosure, which is nothing but a fancy name for a quitclaim deed, a confirmation deed. What type of deed do you think we're going to get on a tax sale? Redemption of a tax property. See, a confirmation deed is just a fancy name for a quitclaim, really. And of course, for tax deed, we only get a quitclaim deed too, but what's it called? Who put the lien on that property to have it go into foreclosure for tax sale? The county treasurer. So what kind of deed is it going to be? Treasurer's deed. Treasurer's deed, yeah. See how simple, see how this all flows together, guys? Not too tough. And again, it's just a matter of don't overthink it. Don't overthink it. So you have your previous way of doing it, and the thing is, when you're talking to people, many of them are still thinking it's done the old way. And you've got to educate them how it's done the new way. And people love talking about how foreclosures work. Very few people have any clue how they work. You guys do. Let's keep going on page 18.6. Plus, we're going to have a lot of questions to cement this for you. 18.6, and look at number 5. Number 5. Confirmation deed means the deed described in that section of the forms specified as this section. Again, a confirmation deed is the type of deed we get in a trustee sale. Go down to number 6. The cure statement means the statement described in the state statute. We're going to look at that in a minute. The deed of trust. That's the same as a mortgage in other states, pretty much. So the deed of trust and the mortgage is the money. Is that right? Yes, no?
Yeah.
No. What's the money? The promissory note is the money, it's the evidence of the debt. What's the deed of trust? It's the property. It's the security for the debt. It's the security for that promissory note. Okay, so we have the promissory note, and then we have security for that promissory note. Now the lender's comfortable in giving us the deed. And the next thing they give us is the title insurance policy. So we know, we have a really good idea of what we just purchased. And then look at number 8, the evidence of the debt. What is the evidence of the debt? Let's read this. It means a writing that evidences the promise to pay. That's the promissory note, is the evidence of the debt. It's the money. The promissory note is the money, not the mortgage, not the deed of trust. They're not the money. They're the security for the money. Let's go to number 11. Next page. The junior lien means a deed of trust or other lien or encumbrance upon the property for which the amount due and owing thereunder is subordinate to the deed of trust or other lien being foreclosed. A junior lienor means a person who is a beneficiary, holder, or grantee of a junior lien. A lienor includes without limitation the holder of a certificate of purchase or certificate of redemption for property based upon the foreclosure of a deed of trust or other lien on the property. Look at number 16 toward the bottom. Notice of election and demand means a notice of election and demand for sale related to a public trustee foreclosure under this article, and an officer means the public trustee or sheriff conducting the foreclosure under this article. And the public trustee is the one who forecloses properties in Colorado. Let's go over to page 1814. Look at number 1 at the top of the page on 1814, third, fourth line down. Everybody there? 1814. No later than 10 business days following the receipt of the notice of election and demand, the public trustee shall review the documents filed pursuant to this section, and if the filing is complete, cause the notice to be recorded in the office of the county clerk and recorder of the county where the property described in the notice is located. The public trustee shall retain in the public trustee's records a printed or electric copy of the notice of election and demand, and the combined notice as published pursuant to sections of the statute. Such records shall be available for inspection by the public at the public trustee's office during the public trustee's normal business hours. So how do you know which property is going into foreclosure? You go to the public trustee's office or the county clerk and recorder's office. You can go online and check out also. Like right now, in all of Adams County, there might be 3. Jefferson County, maybe 2. You just don't see a lot of foreclosures these days. And just as well, because people don't know how to work foreclosures. You do now. You do now. Look on page 1819. I mentioned we're going to look at the cure statement. If you're going to cure your deficit, this is the form you use. It's on 19, 20, and 21. 19, 20, and 21. Then on page 24, 1824, if you want to make a bid at a foreclosure sale, here's the bid form right here on page 24 and 25. 24 and 25. Look at the very bottom on page 1827. We have the usual elements of a deed of trust or mortgage. Same things as the usual elements of a deed. Same thing as a lease. Let's read these. Top of the page. 1828. Kind of gets redundant. They're also similar. We have a date, which may or may not be important. The parties to the deed of trust. Consideration, something of value for something of value. The words of conveyance. Number 4. Number 5, a legal description. 16, the conditions or covenants. The method of sale in case of default. Exceptions as to prior liens, if any. Signature of the trustor or mortgagor. An acknowledgement. Signing before a notary public is the simplest means of establishing the instrument's proper execution and validity. Acknowledgement and notary are the same thing. Write notary on the side there. And recording. Recording in the office of the county clerk and recorder of the county in which the property is situated is necessary to protect the interest of the beneficiary or mortgagee. Who's the mortgagee again? The lender's the mortgagee. The mortgagee, the money, against the claim of persons who may thereafter acquire interest in the property without actual notice of the mortgage or deed of trust. In addition to the above, the following elements may be contained in the mortgage or deed of trust. Provisions for a higher rate of interest in all notes after maturity, if it's an adjustable rate in particular. Top of the next page, an acceleration clause, which triggers a foreclosure. A waiver of homestead rights. Almost every deal you do, you'll waive your homestead exemption. We talked about that in other parts of the course. Reservation of the right to pay taxes. The requirement that a property be insured. And now, see you tomorrow. Okay. Requirement that the property be insured in companies acceptable to the holder of the indebtedness. Provisions for the appointment of a receiver upon the occurrence of a default. And in case of a foreclosure or a trustee sale, provisions for all of those other things there. Now, look at assumption of indebtedness. The buyer and seller may wish to transfer title with the existing loan remaining as a lien upon the property. This is accomplished by a provision in the contract whereby the buyer assumes and agrees to pay the existing indebtedness. However, assumption is subject to limitations that may be present in the mortgage or trust deed contract. Mortgages and trust deeds often contain a provision to the effect that if the subject property is conveyed, the entire balance of the loan becomes due. Due on sale clause. Sales clause. If I alienate myself from the property, the lender's going to call it due. What type of loan is that going to be typically? A conventional loan. Conventional loans are not assumable because they have an alienation clause, due on sale clause. You can't assume them, typically. Next paragraph, the above restrictions may alternatively preclude conveyance without the lender's consent, due on sale. And this enables the lender to adjust, usually upwards, the interest rate or other terms of the loan. If conveyance is made without the lender's consent, the lender may call the entire balance of the loan due. So serious stuff, knowing what you have there. Okay. Let's keep going, guys, on page 1830. Look at the promissory note. That's the evidence of the debt. That's the money, right? In the real estate financing process, the principal promissory note or bond is the evidence of the debt for which the mortgage or deed of trust is the security. This note is an unconditional promise in writing signed by the maker agreeing to pay on demand or at some future time a certain sum of money to the payee or bearer. A promissory note creates a personal liability on the part of the maker. In the event of a default, if the security is insufficient to cover the indebtedness, the holder of the note may obtain a deficiency judgment for the balance due and proceed against all of the property and assets of the debtor. In Colorado, the lender typically is not going to go after you. You know, you have the property and you owe $200,000, it sells for $150,000, so it sells for $50,000 less than what you owed on it. Typically, the lenders, you know, they're going to go after someone who just lost their house, they've lost everything. They're going to go after them for $50,000. That just isn't going to happen typically. But that is a reduction in debt, and it's taxable.
Right.
It's taxable. So that $50,000 could be long-term capital debt. A friend of mine bought this property in Canyon City for $400,000, and on foreclosure it sold for $250,000. They didn't come after him for that $150,000, but he had to pay long-term capital gains tax on it. George Bush dropped that down to 12%. Obama raised it up to 20%, right before this guy got clobbered. So he had $30,000 in taxes on a guy who just lost his home. and you can't bankrupt taxes. So it's just, you know, really tough, playing hardball. Now look at second mortgage or trust deed. Every time you have a mortgage on real property or a loan on real property, you should always have a trust deed, or else you can't foreclose. Look at the last paragraph on 30. When the first deed of trust is satisfied, subsequent encumbrances move upward in priority. The second trust deed would then become first in priority, the third becomes second, and so on. However, the priority of instruments may be controlled by their terms. For instance, the terms of a second deed of trust may allow its lien to continue to be subordinate to the existing first or any substitution thereof, thus allowing the owner to replace the first deed of trust with another without disturbing the position of the lien holder below the first. And this advantage is often very important to the grantor in matters pertaining to refinancing the property. I have a 5% first lien, I have a 2% second lien. So I want to go in and refinance my first. And what happens is the lender tells me, well, I can't refinance your first. If I do, then that second mortgage is going to move up into first position. Remember data recording. It's not the amount. And so what's that lender going to do if he's smart? Going to combine the two into one. Okay, and not allow that to become subordinate, that second lien to be in first position. Everybody following my thinking? Okay. All right, guys. Let's do this. Go into your big 3-ring binder. And go to the end of that second section, Colorado test questions and answers, and go to the end of that, right before Colorado contracts and regulations. Right at the very end of that, you have a 125 question quiz. Now some of those you're not going to be able to answer until we're done with tomorrow. But start working on it. You have 2 nights to complete the 125 questions here. And that's what we're going to do in a couple of days.
Very bad.
Yeah, very back is section 2 there, guys. Now, everybody got that? 125 questions. There's a bubble sheet you'll fill out, and we're going to go over all of those in a couple more sessions. Now, look at the tests right before that. There are 4, essentially 4 74s we call them. There were 74 in each one of them. I whittled them down and added to them. So there's not exactly 74 anymore, but there are 4 74 question quizzes. This is the database for the Colorado portion of the state exam. You've got to know all 4 of these like the back of your hand, okay? If you know all of these 4 74s, we're not going to grade them, we're just going to make sure you read them and you did answer them. If you know all of those 4 74s, it would be virtually impossible for you to flunk the Colorado portion of the state exam. If you know those 4 74s plus 125 we're going to do in a couple more sessions, it would be impossible to flunk the state exam. So work on those 125 questions over the next 2 days. The answers aren't there, so don't go looking for them. We're going to talk about them on Wednesday, or at least a couple sessions from now. So, are there any questions, anything you want to talk about before we break today? Well, in that case, I'll catch you tomorrow morning. That's the end of lesson 8, Colorado Contracts and Regulations.